I want to talk to you about law.
Sure.
You'll correct me if I get it wrong in context, but my sense is that at one point, middle 50s through the end of the 60s, when we had the Warren Court, there was a certain celebration, it seems, over the fact that the Warren Court was an activist Supreme Court.
Mm-hmm.
And by activism, those of us who were so pleased with the direction of the court, what we meant by that was that it was within what we considered to be the rules of the game, within the rules of the Constitution.
Right.
It was at the same time trying to help shape the destiny and the future and the style of this American experiment.
Right.
And that whether it was the Civil Rights Act, whether it was creating the principle or expounding the principle of privacy, which led to Roe v. Wade, whether it was Miranda rights, that somehow the court was taking a role that was appropriate in the broad social structure and legal structure of the United States.
Right.
And I want to understand whether people who look, for example, at the Supreme Court's decision in the 2000 election, where basically they said, yes, we are going to answer the question as to whether Florida, how the Florida count should go in the Bush-Gore election. Or right now, the discussion, Alan, is over whether the Supreme Court has a right to evaluate the constitutionality of the Affordable Care Act of President Obama, what is popularly called Obamacare. And there are some people now who are saying, even the president, was critical of the Supreme Court in a phrase that hurt my ear when he said that he doesn't know whether the Supreme Court should be an activist court, that somehow he was critical of that.
Yeah.
And I want you to give me some perspective as to what did we mean when we applied it to the Warren Court? Is this an issue of whose ox is being gored, or is there something that you can show us about the evolution and the dynamic of the Supreme Court as it applied from the days even before the Warren Court?
Right.
But I'm only taking you from the Warren Court to today in terms of what does it mean to say there is an activist Supreme Court?
Okay, I was a law clerk to Justice Goldberg, who was one of the most activist justices. He was only on the court for 3 years. There is an enormous difference. The Warren Court was activist on behalf of people who had no power, who had no vote. They required reapportionment. They supported the rights of blacks who couldn't affect their own destiny in the South because they couldn't vote in the South. That was what they were doing. They were speaking on behalf of the disenfranchised. That was part of the role of the Supreme Court. They're not popularly elected. They don't have to worry about what the people will think. They were there on behalf of the downtrodden, the unrepresented, the people who had no voice in government. Today's Supreme Court always rules in favor of the big corporations, the big political parties, ruling against people's welfare. It's a statist court, always rules in favor of the state and the large institution rather than the downtrodden. Now, corporations and the others already have access to the presidency and the Congress and the administrative agencies. So there's a big difference. The activist court today is a bully court. It just piles on. When the popular branches don't help the downtrodden, it piles on. Whereas the Supreme Court under Warren played a very different role. It said, who doesn't have power? We're going to speak out on their behalf. That's one difference. The second difference is the Warren Court was not politically partisan. Look at who Warren was. He was appointed by the Republicans. Who else was on the court? Brennan, appointed by the Republicans. Today you can predict the outcome of votes depending on who appointed the justices. You get 5-4 decisions, 5 Republicans versus 4 Democrats. The 5 Republicans vote in favor of the Republican candidate for president. The 5 Republicans vote in favor of letting corporations contribute enormous amounts of money. Who benefits from that? The Republicans. The fear is 5 Republicans will vote to strike down the Democratic health care proposal. I'm not sure that's going to happen, but that's the fear. So we've had two changes. One, the partisan nature of the Supreme Court, predicting the outcome based on who appointed people, whether they're Republicans or Democrats. It's not what courts should be doing. And second, courts should be speaking up on behalf of the unrepresented, on aliens who don't have the right to vote, on criminal defendants who don't have access to the legal justice system. That's the big difference. And it's a principal difference.
Okay. And so be patient with me. My immediate reaction, of course, is that I understand, and you express it so wonderfully in terms of what I would love to see every branch of government do: represent those who need to be represented and to speak out for the orphan and the widow.
But with lobbying, how do you expect that? You can lobby the executive, you can lobby the legislative, you can lobby the administrative, you can't lobby the courts.
Okay. But I wanted a process answer from you. I understand content, and I understand that this court is radically different in orientation and philosophy, and it is a 5-4 split.
Right.
But I remember times when, in history, Franklin Roosevelt was going to pack the court. It turns out he didn't have to because of certain people dying and leaving. But that one of the things that I have always argued, and I've heard you say it too, is that one of the things one should keep in consideration when one decides whom one's going to vote for president is the president gets to choose members of the Supreme Court. And if you choose a president with a philosophy, don't be surprised if he chooses Supreme Court justices when there's an opening that reflects his philosophy. And so for me, there's always been a partisan quality to the Supreme Court. At the moment, the court is 5-4 in a certain direction. If it were 5-4 in the other direction, then maybe Al Gore would be the President of the United States, would have become the President of the United States, and there may have been many more decisions that you, Alan Dershowitz, are comfortable with. But I'm asking you about process.
Well, I think...
Is the process different? Or in fact, there are those who argue the strict construction as opposed to the loose construction. I believe, if you know the Jewish tradition, how the Talmud works, everything is an interpretation.
Of course, everything is interpretation.
Okay, so lo and behold, I accept the notion that when people say to me, no, I'm a strict constructionist, they're interpreting it their way. But I'm asking you, is there something? Is it just that I'm upset with the decisions that are made, or is the process different today?
I think the process is very different. First of all, the process of appointment is very different. In the old days, or when Herbert Hoover had to make an appointment to the Supreme Court, he asked his Attorney General to give him a list. And on the bottom of the list was a liberal Democrat named Benjamin Cardozo. And Hoover said, it's a great list, but you have it upside down. I want to appoint the most qualified judge in the United States to the Supreme Court without regard to his political party or his views. And he appointed Cardozo to the Supreme Court. When Brandeis was appointed to the Supreme Court, similarly, there was a lot of opposition. He and Wilson didn't agree on everything. Today, particularly after the appointment of Justice Souter, who was called a stealth appointment, you can't get an appointment to the Supreme Court unless you've been vetted thoroughly by your positions and unless you've essentially promised, or unless you lie, the way Clarence Thomas lied when he said, I never heard of abortion, I never thought of abortion, or even, Justice, the Chief Justice Roberts, who I like very much, who said, I just call balls and strikes. That's not what justices do. You don't just call balls and strikes. Your ideology plays a major role. So the process, it may have started with Bork, it may have started with Souter. The process by which people get vetted for the Supreme Court has changed dramatically. I also think that the process issue on activism has been confused. I think that it started even with the Warren or the post-Warren court. Roe versus Wade was a disaster for America. I totally oppose Roe versus Wade.
Explain why.
I support a woman's right to choose. I think that abortion is a very important issue, and that I was brought up with the tradition. If I were a Catholic who believed that human life began at conception, I might have a different view. But I was brought up in the Jewish tradition where, life really begins at birth or upon graduation from medical school, depending on how you define it. But life doesn't really begin at conception. that was a hotly debated political issue. There's no right or wrong on abortion. Not only that, but women constitute 51%. They're not a disadvantaged or disenfranchised minority in America. That issue should have been left to the political branches of government. Roe versus Wade is the precursor, in my view, to the conservative judicial activism that we've seen. It also
That's
destroyed,
a very courageous thing for you to say, Alan.
well, it's not courageous. It also destroyed the Rockefeller wing of the Republican Party. When abortion was a political issue, you always had Republicans who supported a woman's right to choose. Once that issue got relegated to the Supreme Court, you get people like George Bush Sr. who changed this view from pro-choice to pro-life, Reagan from pro-choice to pro-life, and many others like that. So it had an enormous impact on the political scene in America, almost all bad. And that doesn't mean I want to see Roe versus Wade overruled. Once you have a decision, there are certain expectations that result from it. But had I been a justice in 1973, I would not have voted for Roe versus Wade. As a legislator, I would have voted for a woman's right to choose abortion.
Yes, but I think what you're saying is you would have said it shouldn't be brought to the Supreme Court.
That's right. I was actually opposed to the ACLU bringing abortion cases to the United States Supreme Court. I wanted them to fight in the legislatures and win the way the fight was being won in almost every state and all over Europe.
Alan, do you believe the Supreme Court had the right to rule in the Florida case in the 2000 election?
No, absolutely not. Certainly had no right to stay the counting. That was a pure, crass political decision. Let me tell you a story. Somebody called me who was married whose child was married to the child of a Republican operative in Arizona. They were having Thanksgiving dinner together with their machatunim. In the middle of the dinner, Sandra Day O'Connor called this guy who was the head of one of the heads of the Republican Party in Arizona. And the guy came back to the dinner with the family with his fingers up like this in victory and said, Sandra just called me and told me it's all set. We figured out a way of doing it. You know, these justices just voted twice. They voted once on Election Day, and then they voted a couple of months later to make sure that their vote on Election Day became the vote of the land. I don't know who would have won the election if it had been fairly counted. You can't tell. I know that the majority, not even a close, but a substantial majority of Floridians intended to vote for Gore. 6,000 or so had ballots that were mismarked because of the butterfly ballot. Others were kept from voting at the polls. But I don't know what a recount would have done. But the Supreme Court never, ever should have been in that case.
Should the Supreme Court have the right now to review the Affordable Care Act?
Certain aspects of it. For example, if you're a Christian Scientist and you'll never use the hospitals and you would make a commitment not to use the hospitals, you can make an argument that a person like that has the right not to be compelled to take medical insurance. There might be religious exceptions. In general, the law is constitutional, certainly under the Commerce Clause. Clearly, medicine is commercial. I mean, I live in Florida part of the year. I have to use medical facilities down there. I'm in New York. I've had to use medical facilities here in Cambridge, Massachusetts, particularly the elderly. Everywhere we travel, we need to have health care. Medicaid and Medicare clearly are national, so I think health care is a national problem.
Are you saying, yes, the Supreme Court has the right?
They have.
In other words, is it appropriate for the issue of affordable health care? Should that be an issue that the Supreme Court should listen to?
It should, and it's an easy case under the Commerce Clause. Under the Commerce Clause, it should be 9-0 that the Supreme Court has the authority to regulate health care. There might be some exceptions that are required under the Constitution for people who shouldn't have to buy insurance.
Are you worried now that this Supreme Court will strike it down?
I'm not sure. I can't predict the outcome of any case, but of course I'm worried. You know, I have friends who have children who are uninsurable because they've had prior medical problems or have limits on their insurance. I want to see all Americans protected in their health care. I also always want to make sure that we have the option of not using the health care. I want to make sure that I have the right to use my own money to get a doctor who's outside the system, unlike in some parts of the world. So I think this health care bill generally should be upheld.
And did they make a mistake when they said everybody has to buy it?
I think they should have had a provision in there with some opt-outs, but it's very hard. No emergency room is going to turn down somebody who doesn't have insurance. Look, I'm in favor of everybody having a card that they carry around with them, whether they're an organ donor. And if you're not an organ donor, I think you get to the bottom of the list of organ recipients. Israel has now moved in that direction. Fortunately, thanks to the incredibly brilliant work of Rabbi Yitz Greenberg, who went to Israel after his son tragically died and gave all the organs of his son to save lives of Palestinians, of Christians, of Jews, and made it clear that halachically there is an obligation to be a donor because there had been some who had taken a different view. And the idea that you can receive but not give organs is an entirely immoral view. So I don't know how we've gotten from Iran to organ donation, but you're a terrific questioner, so you managed to cover everything.